Welcome everyone, my name's Corey Allen and this is the Overton Report. Today is the 30th. Year's almost over. So today I want to talk about a specific court. Now, many people have never heard of this. Now in Charleston, South Carolina, which is where we here at the Overton Report are based, in the year 2002, a new court was established. So the name of this court is the Livability Court and the Livability Department. Now, since its creation, it has faced a lot of questions about its constitutionality, and at the same time, it has spread throughout the state and throughout many parts of the nation. The intended purpose of this court was to take some pressure off of the local police to deal with relatively innocuous things. Trash complaints, noise complaints, pet complaints, those types of things, Neighbor versus neighbor, kind of like HOA stuff for people that don't have an HOA. But soon, their jurisdiction began to increase. Then they began being put over tour guides, the horse carriages, the walking tours, things like that. Licensing, that type of stuff. Around 2014, 2015, the court came under scrutiny again. It wasn't the first time and it wouldn't be the last time. A case was filed with the state Supreme Court, South Carolina State Supreme Court, by a property management company over a littering dispute at one of their rental properties. The South Carolina Supreme Court dismissed the case, and the fines that this property management company were facing went ahead as written. Basically, anytime this livability court has been scrutinized or questioned, somehow they get around it. And this, of course, has allowed the Livability Department and the Livability Court to thrive as a revenue-producing stream for the City of Charleston. What's interesting about this court is that they've had a single judge and a single director since their inception in 2002. Former Charleston police officer Daniel Riccio, he's the director and the de facto leader of the Livability Department. Judge Michael Maloney has had the seat on the Livability Court since 2002 as well. And these two men, they run the entire Livability Department under the direct control of the mayor, Mayor John Tecklenburg. Very far left dude, has really done a lot of damage to the city. This year, however, the Livability Court, which is already constitutionally questionable at best, has been given unprecedented authority on the day-to-day lives of every individual on the street. Now, this has happened, of course, due to COVID-19. These mandates, which were handed out by the mayor of Charleston and the council, it's happened here like it's happened in many other cities. Now, the livability officers, they've taken this new authority to heart, and they've seemingly been using it with reckless abandon. Now, what are the court's abilities? The court is able to write tickets up to $1,087, as well as send a person to jail for up to 30 days. The mask mandates that were put in place in the city of Charleston include walking down the street or being in a park, in a place where you can't at all times be 6 feet or further away from somebody. And of course, in stores, restaurants, the capacities are very, very reduced. Now here's the problem. These officers, these livability officers, are unsworn officers. They have not sworn an allegiance to the Constitution or the city or the citizens or anyone except for the court and the person signing their paycheck. That would be the mayor. So with this new sweeping authority given to the Livability Department, the constitutionality of it has been called into question once again. The Livability Department is currently facing at least 3 lawsuits simply from the tickets given based upon the mask ordinance. Now, up until a couple of months ago, you would get a warning for not wearing a mask, and then it would be followed by a $100 ticket, then a $2, then a $5. But they took the warning away a couple of months ago. So that's been an issue. Now, these lawsuits are claiming that the fines that this court has been dishing out have been used in a retaliatory nature. We've covered this a couple of times briefly. Mainly, they're being used against tour guides and restaurant owners and store owners. Now, one story goes something like this. A horse tour operator was eating his lunch out of a container, standing next to the carriage. When you're eating, you don't have to wear a mask. Obviously, you can't do that, right? So he puts his container down and does a check around the carriage and the horse. And by the time he gets back to his meal, which again, he's still in the middle of enjoying, a ticket is being written to him. Now, it happened a couple of times to this guy. They kept writing him ticket after ticket after ticket. He is claiming that it's being used in a retaliatory way. Now, another story claims that the director, Riccio, Dan Riccio himself, walked into a restaurant multiple times throughout the day and wrote multiple tickets to the owner of a restaurant because people were standing up without their masks on while enjoying a beer or whatever. Of course, we all know at this point that COVID only spreads at 5 feet and above, right? So if you're sitting down, you're safe. But since these people were standing up, obviously the city needed to teach that bar owner a lesson in such a hard year for businesses, right? Had to get that money, wrote multiple tickets. So these lawsuits are going through. We'll see what happens with them. So now this is where it starts to get real crazy. Bars in Charleston are allowed to stay open past 11 o'clock. And of course, they used to be able to stay open until 2 a.m. until they also found out that COVID doesn't spread before 11 p.m. So they took those 3 hours out, which are, some of the highest revenue hours for these downtown bars. But the bars are not allowed to serve alcohol after 11 p.m. Also, nobody within the bars are allowed to drink alcohol after 11 p.m. So why? Don't ask me. I don't know. I don't know why. Except, of course, for the fact that the hours of 11 p.m. to 2 a.m. are, the worst for catching COVID. This left a lot of people wondering what would happen during New Year's Eve, which, as we all know, the celebrations on New Year's Eve began about an hour after the arbitrary COVID cutoff time. Now, riots, closures, reductions in capacity, all of these things and some other issues that our city has caused, city officials have caused, they've forced many businesses in downtown Charleston to shutter their doors, never to reopen again. And on potentially one of the biggest nights for revenue, the city and its constitutionally questionable Livability Court have decided to double down on their harassment of the remaining businesses and owners trying to provide for their families and their employees. So get this. They've decided to walk from bar to bar starting at 11 p.m. to make sure that their arbitrary and abusive mandates are being followed without exception. So listen to this. This is Livability Director Dan Riccio, and let's hear what he has to say.
The penalties are pretty tough. If an establishment is in violation of selling or allowing consumption of any alcoholic beverage after 11, they could lose their license to sell alcohol.
I know that was hard to understand because he's wearing a mask by himself in his car while giving an interview. But here, let's play it again. I'll put up some subtitles.
The penalties are pretty tough. An establishment is in violation of selling or allowing consumption of any alcoholic beverage after 11, they could lose their license to sell alcohol.
While this kangaroo court continues infringing on the rights of business owners to provide themselves a living and continues to interfere with the lives of the city's citizens, even more than usual, we have to keep something in mind. And that is that these livability courts, they're spreading across the nation now. Now, one question is there a place for courts such as these to mediate relatively small issues in the communities? Maybe. But the problem comes when they're given broad and sweeping authority, as they have been, to use however they see fit, without any checks or any balances. And also, a problem arises when restrictions aren't put on these types of courts in very precise and certain terms. Unfortunately, that never happened with this court, and it doesn't seem like it will happen, at least not for the foreseeable future. But here's the thing. If you're walking down the sidewalk in Charleston or any other place that has these livability courts, just remember this. Smoking cigarettes is one exemption to wearing the mask outside. That's right, spark up. Because the City of Charleston has officially declared that inhaling tobacco smoke is healthier than inhaling oxygen without a mask. And if you don't smoke, just keep a lollipop on hand and you'll be fine, because eating a lollipop is also an exemption to wearing a mask in Charleston, South Carolina. And also remember that on January 5th, 6th, and 7th, we will be in Washington, D.C., covering whatever insanity is going to happen there. So share this video, sign up for our Substack newsletter, and tag a friend. As always, thank you so much for your support, and we'll talk to you next time. Until then, my name's Corey Allen, and this has been the Overton Report.